Distinguished guests on the dais and also the distinguished guests in the conference hall, my beloved students. The mandate to us is that from the moderator, we should avail 20 minutes time. I thought Justice Swaminathan will take our time also. That is what I expected you to do that. We are all retired law ministers in the state, retired law minister in the center. But you are the active practitioner in the High Court. Anyway, I will also try to make it as brief as possible, not to prolong things. One mandate I don't think we can respond to. Guru of law faculty, Professor Ishwar Bhatt said, you must give rapt attention. In the noisy democracy like us, I think this is against the constitutional morality. So, I don't, expect rapt attention, but of course, you can show your all passion and anxiety when you participate in questions. To that extent, I think we can moderate this discussion. According to me, the simple meaning of the constitutional morality, after making a full study of the entire gamut of situations, is adherence to rule of law. But at the same time, I think, it is not just like the flesh of, the Merchant of Venice case, where Sherlock demands the blood of not the flesh, and that is how the justice. That is how sometimes the rule of law may, without tempered by the humanity, human feelings, ultimately cannot get justice at all. This is what I would like to initially say this. Our constitution making itself is a very big, marvelous exercise. They have come out with the social justice, which enables the courts to uphold legislations, to remove economic inequalities, to provide a decent standard of living to the working people, to protect the interest of weaker sections of the society. Doctrine of equality is the essence of democracy and is a basic structure of the Constitution, feature of the Constitution. Secularism, again, is the overarching principle of several rights and values under the Constitution. Secularism is nothing except universal. You can't discriminate between men and men, group and classes. In fact, the morality is a philosophical term whose connotation changes with the changing time and changing needs of the society. According to Professor Hart, the standards and morals are necessary in our law because in view of the highly variable nature of possible combinations of circumstances, it is not always possible to identify in advance the relevant features of the cases to which rules might be applied. The concept of constitutional morality refers to the ethical ideals that are derived from the core values enshrined in the Constitution and also supplementary to them. And the constitutional morality requires that allegiance to the Constitution is non-transactional. This is what we ultimately arrive at it. Even our preamble to our Constitution contains the most impeccable goals whose realization requires greatest commitment to morality. Corruption-free, transparent, accountable governance will go a long way in making one and all in India realize their potential. This is the environment which is created. Constitutional morality is a well-set environment which is created where the core values of the Constitution can work and function. It's already said and quoted that Dr. Ambedkar, he spoke on this first subject, was raised by, in fact, by Dr. Ambedkar and quoting the Greek historian Grote. In fact, Grote, a Greek historian, said, the diffusion of constitutional morality not merely among the majority of any community but throughout the whole is the indispensable condition of government, at once free and peaceable. Since then, any powerful and obstinate minority may render the working of the free institution impracticable without being strong enough to conquer ascendancy for themselves. This is what is a constitutional balance, ultimately. That kind of an environment to be created. For Grote, the prevalence of constitutional morality was the indispensable condition of a government at once free and peaceful. And constitutional morality meant, Grote suggested, a paramount reverence for the forms of the Constitution, enforcing obedience to authority and acting under and within these forms, yet combined with the habit of open speech or action subject to this. Both Grote and Ambedkar accepted the rarity of constitutional morality. Grote's history of Greece had been motivated in part by a desire to rescue Athenian democracy from the condensation of its elitist critics such as Plato and Thucydides, and argued that Athenian democracy had, even if briefly, achieved elements of a genuine constitutional morality. For Grote, there were only two other plausible instances in which constitutional morality has surfaced. First was the aristocratic combination of liberty and self-restraint experienced in 1688 in England. The second was American constitutionalism. All other attempts had failed. For Ambedkar, this lesson was an important one, adding to the worry of creating democracy in a country like India, whose society was entirely lacking in democratic spirit and experience. It is that is how we say that the Constitution of India is the biggest experiment. I don't think in any other country such a constitution with a synthesis would have worked. But it would work only in India. We should be proud of that. Ultimately, constitutional morality means adherence to the core principles of the constitutional democracy. Ambedkar says that the maintenance of democracy requires that we must hold fast to constitutional methods of achieving our social and economic objectives. It must mean that we abandon the bloody methods of revolution. It means we must abandon, even he has gone to the extent of saying that we should abandon even the civil obedience, satyagraha and many of the other things. This is to that extent, because he says that in democratic functioning, there is no scope for any other methods except the constitutional method. This is what Ambedkar has definitely, told us, Therefore, the constitutional morality requires that allegiance to the Constitution is non-transnational, which I told you already. Essence of constitutional morality is that allegiance to the Constitution cannot be premised upon it leading to outcomes that are a mirror image of any beliefs. Ambedkar, in fact, the third element of constitutional morality is suspicion of any claims to singularly and uniquely represent the will of the people. Ambedkar is very reluctant to see any branch of government, whether it be the legislature or the courts or even the Constituent Assembly itself, as being able to claim authoritatively that it embodies popular sovereignty and speak in its name. He is often suspicious of all these bodies. That is how he gave a mandate. Ambedkar always said that without fraternity, equality and liberty, there cannot be a democracy. He said, ironically, that equality and liberty would be no deeper than coats of paint. This is what I said, it has to be seeped deeper into the psyche of the nation. That was his intention. But he was not very sure about it. He was suspicious about that. He made an argument that the Constitution is about distribution of power among different classes of people, and also he said, it should be a deliberate attempt to do that. On the final analysis, Dr. Ambedkar pitches for constitutional morality and allegiance to constitutional forms rather than collapsing the domains of constitutional and distributive justice. He does not cheat by giving us the false assurance that the forms of constitutional morality will not produce deep substantive equality. Constitutions not only allocate authority, define sense of history, and shape a sense of self. They often mark a new beginning and define future horizons. I'm again coming and would like to draw your attention that while the Constitution was an extraordinary work of synthesis, which you don't find it anywhere in the world, our historical imagination is given to divisiveness. There is no more striking example of this than in which the members of the Constituent Assembly have been divided up, appropriated, rather than seen in relation to each other. Ambedkar, Patel, Nehru, Prasad, and a host of others are now icons in partisan ideological battles. They were not in agreement with many of these ideas. In the modern term, I must say that to describe Ambedkar as a Dalit, or Patel as prototype BJP, or Nehru as a congressman exhausts all that needs to be said about them. We should read in today's context, the personalities who were involved in making the Constitution. Greatness of each one of them consists not just in distinctive points of view they brought together, but their extraordinary ability to work together despite so many differences. This is a lesson we should present contemporary politicians, statesmen should learn. I think they must be asked to go back to the Constituent Assembly, how they differed, how they fought, how they found a synthesis. Now we fall apart and not to come back for any synthesis. Democracy cannot work like that. Our Constitution was evolved. Democracy started functioning. With all the differences, you can't make, you sort out the difference, come to the platform to discuss. That won't happen in this country. Should not happen. But the beauty in conflict resolution. I would rather say the Constitution of India is a document of conflict resolution, par excellence. You don't find it in anywhere else. They sink the difference. But in other countries, they do not sink the difference. They don't find the synthesis. There is no process of any conflict resolution. Any problem, you need not go to any other document, any other legal document or otherwise. It is there in the Constitution. You find a solution. Is a solution provider. That is why we are proud of our constitutional fathers, always. And in fact, the greatness of each one of them consists not just in the distinctive points of view they brought together, but their extraordinary stability worked together despite so many difficulties. Congress itself facilitated the entry of so many people with an anti-Congress past into key roles in assembly. They were anti-Congress views, but they worked together. They found the synthesis, solutions. It takes a willful historical amnesia to forget the fact that the men and women of the Assembly, Constituent Assembly, worked with an extraordinary consciousness that they needed and completed each other. The historical, each one of them were complementary to the others. Not, going in a different direction, parallel. They needed to complete each other. The historiography of the Constituent Assembly has not regarded it as the exemplar of constitutional morality. It has rather assessed it as a much, much more ideological asterisk. That's why, of course, with the subject to the views held by so many people, that, the document is constitutional document itself and reflects constitutional morality. That's how we could evolve at that point of time and those solutions. The remarkable was that their ability and acknowledged greatness. Even as partial, a biographer of Nehru, S. Gopal, conceded that what prevented the rupture was their mutual regard and Patel's stoic decency. We should be proud of that. They are the real icons, whichever view they held. Whichever view, it can be interpreted, but ultimately, they could respect each other. Respect was a basic thing. This is what is necessary in democracy. Democracy to function well and smoothly. And this is the background which I would like to provide today. And with that background, we should, go through the constitutional morality or any of the decisions given by the high courts or the Supreme Court. That I would like to come to a conclusion that the Constitution was made possible by a constitutional morality that was liberal to its core. Not liberal in the eviscerated ideological sense, but in the deeper virtues from which it sprang. An ability to combine individuality with mutual regard, intellectualism with a democratic sensibility, conviction with a sense of fallibility, deliberation with decision, ambition with a commitment to institutions, and hope for a future with regard for the past and present. That is why it just like a rock, it is perennial, permanent. Our Constitution can take care for another 1,000 years. This is the beauty. That doesn't mean, we should not amend the Constitution, and that is already provided in the Constitution itself. Changing pace of judicial review will cast newer responsibility on the judges and the judiciary. In the United States, the due process clause brought in its own contradictions. In India, in the very first case of Gopalan, the court went by the printed word giving it positive meaning. Law and legislation became synonymous. Sometimes, judges interpret legislature and law is different. Law is what we determine. Legislation, what the parliament. There is no compartmentalization. It is law and the legislation one are the same. The words procedure established by law became nothing more than procedure prescribed by the legislature. Laws became a mere enacted apparition. This is what, now slowly we are forgetting, judges are forgetting, lawmakers are forgetting, everybody is forgetting the consistency in interpreting law, which should be actually defining the legislature which enacted the act. However, in the US, pendulum swung too far in favor of very wide interpretation of the court's power under the due process clause. That had its own political repercussions. The turnaround began in the 30s of the last century in Colgate versus Harvey, 1935. The dissenting judge reminded the court that it must fastidiously observe the admonition of Brandeis, Stone, and Cardozo that we do not sit as a super legislature. Judiciary or anybody cannot sit as a super legislature. That dissent became the majority view in Ferguson versus Scupa. The court said, we refuse to sit as a super legislature. This is what US court said. We refuse to sit as a super legislature to weigh the wisdom of legislature. And we emphatically refer to go back to the time when courts issue the due process clause to strict down state laws regulating of business and industrial conditions because they may be unwise, improvident, or out of harmony with a particular school of thought. Of course, we have gone further, even the constitutional provisions, again, we try to, without understanding what the Constituent Assembly debated and deliberated to bring out the synthesis, unless that spirit of the deliberation is understood, any interpretation of law by the judiciary or anybody will not help. Justice Blake added, we have returned to the original constitutional proposition that courts do not substitute the social and economic beliefs for the legislative bodies who are elected to pass law. This is what America has gone back to, because still I think Satyanarayana Sinha, who first presided over the Constituent Assembly, she said, we are going by US law while making the Constitution. I think this has a relevance to that particular statement. The guidance which was given. Supreme Court of India first phase was a precedent-ridden court. When we all started, I think even when we had started, working in the lower courts, subordinate courts, district courts, we were all, looking for the precedent. I don't think any court is now, or any senior lawyer or a junior lawyer, is particular. I think that mindset, am I correct, Justice? We are no more precedent-ridden. It's good. It's a good evolution of law. Gopalan case was the classic instance of how the printed text guided the court's positivist interpretation. 70s saw the court emerging as a creative institution, coming up with the new tools for legal control of government. Judges emerged in the Lord Denning's model of bold spirits, not mere timorous souls. This was the emerging trend in the other judicial systems of the English-speaking world, as well as in the wake of expanding horizons of human rights philosophy. The Supreme Court of the United States took the due process clause so seriously that it ought to give, it thought that it gave the court power to strike down laws on the grounds of unconscionability. So much so that an exasperated commentator exhorted that the Constitution of the United States of America needs to be saved from the Supreme Court of the United States and the Supreme Court from its own judges. This is what was by the many scholars, jurists. Some critics continue to say that our Constitution was not written on a tabula rasa and it was only a mirror image of the Government of India Act 93, which is not correct. We just said, very casual, let's say casual remarks on our own great constitutional, Constitution making in India was a sublime and an extraordinary event in history. Coming as it did in the wake of a new wave of global democratic urge. It sought to bring within a subcontinent of great diversities unimaginable to their range and complexities within the common wants of justice with the objective of transforming a feudal society into a modern egalitarian industrial society. Remember, it was not a nation, what we call as a Bharat, when the Britishers left us. It was something, splintered everywhere. Many islands in the country in terms of unity. In fact, that also our constitution was drafted at the time when there was total bloodshed in the Second World War. That was the situation. And just imagine how even an issue touching the right of person professing the Sikh faith to carry a kirpan had to be recognized and accommodated in the constitutional document. It may look when you look back, it may look as if, it is a small matter, but no. That means to say the entire national sentiment synthesized in a great document of the Constitution of India. We must be proud of our constitutional fathers. The world was just emerging from the holocaust of a devastating world war and was forcibly looking up to an era of peace. Everybody was after, because this is the concept of peace driven all the divisive people who are having different voices together. New hopes were rising in the horizons of a tired world. The emergence of an independent India was an exciting global event. For Indian, it was nothing short of a great spiritual event. The debates in the Constitutional Assembly rose to sublime heights. The whole world was watching with anticipation and excitement the political developments of the Indian subcontinent. The exhaustion of the ideal of universal adult franchise raised doubts in the Western world as to how 330 million ignorant Indians could manage the sophistications of a parliamentary democracy of the Westminster model. The experiment was described as the biggest gamble in the history by Westerners. But the same Western press later said that Indian democracy was robust, but added a rider that it was also the rowdiest. This is how they looked at it. But we made it. India has made it. We should be proud of India, proud of Indian who drafted the Constitution, thereafter implemented the spirit of the Constitution of India. The very avowed philosophy of the Constitution is the inspiration as to the new role of the judiciary under the Constitution. Some critics called the constitutional document elephantine and a paradise for lawyers. Should all the Constitution provide for administrative details? This is the question raised. But Dr. Ambedkar said the form of administration has a close connection with the form of Constitution, and it is perfectly possible to prevent the Constitution without changing, to pervert the Constitution without changing its form by merely changing the form of administration and to make it inconsistent and opposed to the spirit of Constitution. With all this, because many people are asked, why such a big volume, even the minor details of the administration, why should it be there? And in fact, we need to work out wants. That is how Justice Holmes said. Roscoe compared the work of the chemist who does not make the materials which go into his test tube, but only selects them for some purpose that gives form to the result. Similarly, as the Carlton Kemp Allen said, the judge does not create the raw materials for his judicial legislation, but uses only the existing raw material. And that existing raw material can come from the legislature. That means the judiciary or the judges take that raw material which was available in the deliberations to the Constituent Assembly, raw material which is available, in the deliberation of the parliament in enacting a law or the state legislature. If you lose out of it, I think you have lost sight of the real constitutional morality. This is what constitutional morality is not written down in the Constitution, but it is written down in the hearts of the people of this country. And with that constitutional morality, this Constitution was drafted. It's so simple. And it's not something foreign to us, foreign to the making of the Constitution. The reason, that is what, I would like to say that. And, there are many judgments came that I accepted. I think more than 10 judgments, including the judgment on triple talaq, or, on the question of 377. And many of them, I am not going to narrate this. I think Justice Swaminathan has briefly stated that the reading down of the section 377 of the Indian Penal Code so as to not to cover the LGBT community members was an instance of discrimination. Again, adultery was another issue which was dealt by our courts, and all arising out of the constitutional morality, and that constitutional morality is, according to me, that was the underwritten law between the lines of the Constitution of India. Not much is something borrowed from the Western countries or anything there. In fact, even if every person may not wish for the death of constitutional morality, because it's a very, very dangerous weapon, as said by our AG, K.K. Venugopalan, he rightly said also, I don't dispute about it. It would be foolhardy to disagree that the application requires utmost caution and restraint. For as the adage goes, even divine nectar, when in excess, becomes poison, in this case, for the society. So excess use. Even a nectar can become poison. I think this every judge should be quite conscious of this. And in fact, our guru of the Mahaguru of the Gurus, N.R. Madhava Menon, he has put some questions, particularly on the debate, Upendra Bakshi and AG and all that. After that, he put forth some questions. I don't want to get into details. What he said, number one question, as an overarching principle of constitutional governance, is not the concept of constitutional morality and whatever it means applicable to all three wings of the state and the citizens. Not only applicable only to the, sometimes we get an impression it is applicable only to the judiciary. No. It is applicable to all the three wings and citizens also. If so, when the legislature which represents we the people makes a law, is it, very sorry, I will take another 5 minutes more. We the people makes a law, is it not fair to say that such a law can be presumed to incorporate constitutional morality? Should the court in such circumstances be obliged to seek strict scrutiny and positive evidence to strike it down through judicial review? Number two, is there any justifiable fear in the public mind that too much power is getting concentrated in the judicial wing without proper checks to prevent judicial excesses, and that works to the detriment of not only constitutional morality and rule of law, but to basic structure of democracy itself? Third one, given the fact that there is no single Supreme Court decide on the constitutional questions and there are multiple courts depending on the constitution of benches, and also given the fact that often the important constitutional questions are decided by benches and a 1 or 2 vote majority, and further given the general impression that the rule of collegiality is very often missing among judges, how does the power dynamics of the bench impact on constitutional governance and the rule of law? These are all the questions for all of you, all of us to examine seriously. Fourth, is the court free to invoke constitutional morality decide against the text of Constitution, as in the case relating to appointment judges to the higher judiciary. Judges appoint themselves. I don't think it is acceptable to any democracy, any constitutional democracy. But it still is done. Is the court free to invoke constitutional morality to decide against the text of Constitution, as in the case relating to appointment judges to the higher judiciary? Fifth, when constitutional morality is invoked by judges of the same bench to come to opposite conclusion, as during Sabarimala judgment, what is the message it gives for constitutional governance and the rule of law? Should not be. Any decision either by the legislature or the judiciary or the executive should be opposed to constitutional governance and rule of law. That is so clear. I think it's good that these debates are coming up and we are discussing today. I think many more such discussions should be held all over the country. Sixth one, the court, the custodian of people's faith and belief as well, can it possibly interdict on customs and practice traditionally followed by religious denominations on grounds other than what are provided for in Article 26? Article 26. Are there judicially manageable standards to evaluate every religious practice in every religion? Is not complementary to the constitutional institutions also part of the constitutional morality? Seventh, what happens when two fundamental rights, one guaranteed to individuals, other to groups of people, contradict each other? If right to privacy is interpreted to mean the prevention of the state taking necessary steps to ensure security, what will happen to right to life and right to freedom of individuals? Who is best to judge the right balance between the liberty and security in the era of terrorism and digital transaction? I don't want to elaborate on these subjects. Could Dr. B.R. Ambedkar be wrong when he said that constitutional morality is a sentiment which has to be cultivated among the people as it is not natural to them? It may not be natural to them, it is natural to the Constitution of India. I must say that. The Attorney General be faulted when he said that as far as Dr. Ambedkar's invocation of doctrine is concerned, it was more a mandate to the people and their representatives rather than additional source of power to the court. I emphasize the word. It's not an additional weapon given to the court, but it is more so to the people and their representative. I think a lot of clarity is necessary on all these things, and of course I have many other points which I don't want to take away the time because the mandate of, I don't want to violate the mandate of Professor Bhatt, and in fact, there are many things which I could have said, but and Dr. Ambedkar, I quote one last thing. He said to the Assembly, Constitution, if the future parliamental wishes to amend any particular article, all that is necessary for them is to have a 2/3 majority. And again he said, those who are dissatisfied with the Constitution have only to obtain a 2/3 majority. I emphasize the word 2/3 majority. Then what happened to Keshavananda Bharati case? Many other cases. I think the time has now come to review the ratio decidendi laid down in the Keshavananda Bharati. And of course, I have a lot of notes on that, but since there is no much time, I don't want to detail and illustrate on these things. But anyway, it's an excellent subject which has chosen by Symbiosis University on this, and I think country has to revisit itself on some of these decisions of the judiciary so that we restore back the sanctity and the nobility of the Constitution of India. Thank you very much for the time given to me, and if there are any questions, I can answer them.